couple more things we need to touch on so we can wrap up this landlord and tenant act. And the next thing you see here is remedies in case of abandonment. Abandonment's really what we're talking about here. Now, first of all, what is abandonment? You need to know that. But that's 15 days of unexplained absence. Now, why does it matter, and why might I have to prove abandonment? It is not unusual for some tenants, right in the middle of a lease, to just pack up and move out overnight. They may have several months left on their lease. They don't say anything. They don't tell anybody anything. They just pack up and leave. They just disappear. Well, typically when that happens, rarely do they take everything they own with them. They leave stuff behind. Now, a lot, if not about all of what they leave behind, a lot of times is just trash, junk. But occasionally they'll leave some stuff that might be worth something. They might leave some furniture or something like that. And some of that furniture might be pretty good. Well, the question is, they're gone. You want to get it rented out to somebody else now. Well, what do you do with all the stuff they left behind? Well, first of all, before you can do anything with it, you better be able to prove it's been abandoned. Because, you just go in there assuming they've moved out and then start throwing away all their stuff, take it to the dump or whatever. If they come back to get it, you might be shocked at the value of the stuff they left behind when the judge gets through with you. But anyway, so we have to be able to prove it was abandoned. Well, we know abandonment is 15 days of unexplained absence. But the real question and what you got to be able to prove here is, when does that 15 days begin? By law. And there are actually a few different possibilities as far as the start date between for that 15 days. And what you're looking at there in paragraph B, if the tenant, when they decided to move out, if they contacted utility, the power company, or maybe water company, whatever, because that stuff is in their name and they don't want to have to keep paying for it, they may contact the utility company to have the utilities turned off or disconnected. Assuming they did that, the day they contacted the utility company, you can use that as the first day of abandonment, and then 15 days later, now you can go in there and clean it out. But some other if they didn't turn off the utilities, then maybe then the first day the rent was due, and obviously has not been paid. Then again, 15 days later. But what is saying here in paragraph C, and this is something you got to really be careful of. A lot of landlords say, well, it really doesn't matter if I find another tenant or not, because they still owe me 4 months or 5 months, 6 months of rent that's still left on the lease, and I can still go after them. And there is some truth to that, but the law does say if a tenant abandons the property, then landlord, you have an obligation to search for and try to find another tenant. If you just leave it vacant and you don't look for another tenant, your lack of action as a landlord will terminate the lease. So then the outgoing tenant does not owe you anything at that point. You can't go after them for the rent. So you have to actively pursue another tenant to move into that property. As long as you're doing that, now first of all, if you do, or when you find another tenant, the day they move in in that property, that also terminates that old lease. But at least now the tenant that abandoned the property, they still owe you legally. They still owe you rent from the time they left all the way up until the time you rented it to somebody else. But the main thing I want you to make sure you understand here, y'all, if you just don't seek or look for another tenant, that lack of action will terminate the lease, and now you can't go after the rent. Okay? All right. The last thing I believe about the Landlord and Tenant Act is dealing with retaliation. In fact, it says retaliatory conduct is prohibited. And really what they're talking about here, y'all, if a tenant takes the landlord to court, and assuming the tenant wins and the landlord has to pay 3 months rent or whatever, y'all, obviously the landlord's probably not going to be very happy with the tenant. Well, could you see where the landlord might have a feeling that they want to retaliate in some way against the tenant? Well, that's what this is. Y'all, that's a no-no. Y'all, retaliation is illegal. Y'all, you cannot do that. Y'all, you can't try to force them out. You can't just terminate the lease and tell them to leave. Y'all, all of that is considered retaliation, and that's a no-no. You cannot do that. Now, a couple things you need to know for test purposes concerning retaliation. Y'all, let's say today is the 15th of the month, and the lease, it just so happens, is going to be expiring the end of the month anyway. And the landlord does not want them to stay. Well, does the landlord have to renew the lease once the lease expires? No, they don't. They do not have to renew the lease. However, the law says if the reason you're not renewing the lease is out of retaliation, then you must give the tenant a minimum of 75 days notice to vacate. You couldn't just say, tenant, you know what? The lease is expiring the end of this month anyway. You need to plan on being out of here because I am not going to extend the lease for you. You need to get out. You cannot do that. Y'all, you have to give them 75 days notice to vacate. Now, do they have to pay rent for that additional 75 days? Yes. They still have to pay the rent. But you can't just say be out by the end of the month. You have to give them the 75 days notice. Now, with that being said, y'all, if you recall, I've been saying, certainly in the previous hour, y'all, almost every time you go to landlord, the magistrate's court to sue the landlord, y'all, the penalty, assuming you can prove it, is pretty much always 3 months rent or twice the damages sustained. Remember, I told you better remember that. But I also said there's one instance when that penalty would be different, and this is it. Y'all, here, now first of all, if you're going to sue the landlord for retaliation, you better be able to prove your case. Because if the courts deem that what you're alleging is without merit, in other words, you cannot prove retaliation, then it says the landlord would be awarded 3 months rent or treble the damages sustained. Now, what does treble mean? 3 times. Why they don't put just 3 times, I don't know. But 3 months rent or 3 times the damages sustained. Y'all, that's different than the 3 months or double or twice the damages. But if the tenant can prove retaliation, then the landlord will have to pay the tenant 3 months rent or treble the damages sustained, again, whichever is greater. So, y'all, that's the only instant really that where the penalty, fine, if you would be different. So I'd pay attention to that. And y'all, that's your Landlord and Tenant Act. Now let's look at some other laws, such as the South Carolina Vacation Timeshare Plan Act. Y'all, I'm assuming people are familiar, or at least heard of timeshares. but obviously there is a law that governs how timeshares must work or how they operate. First of all, anybody that's going to be selling timeshares in South Carolina, these timeshares have to be registered with the Real Estate Commission. The commission will likely inspect all the documents. They want to see all the contracts that they're going to be using. So all of this has to be approved by the Real Estate Commission before they can sell any timeshares in South Carolina. Within the contract of sale, again for a timeshare, you see some things that must be there. The date the contract's executed, name and address of the seller, total financial obligations, terms of the contract. But number 5 there, that's the one I'd probably pay the most attention to. There has to be a 5-day right of rescission. Basically meaning, from the time the contract is signed by the buyer, you actually have 5 days to come back to your senses and decide this is not a good idea. And as long as the buyer terminates the contract, which they have every right to do, even though they've signed it, they can still terminate that contract without penalty. Any monies they put up in advance, which you typically have to do that. But any monies you put up in advance, you'll get all of it back as long as you rescind or terminate the contract within 5 days. You got to remember that 5-day rescission period. I promise you they'll ask you that. Okay? Now, obviously, the money you put up at the time you sign the contract, and, by the way, buying a timeshare is very similar to buying a house. When you sign the contract, typically the buyer will put up some amount of money, kind of like earnest money. It's not the full value of the property, just some percentage or some amount. But obviously, all of that money that's put up in advance must be kept in a trust account. And if the buyer decides to rescind or terminate the contract, again within the 5 days, then obviously then the timeshare company has to return all their money within 20 days of the buyer terminating the contract. Now, I didn't say this on the previous slide, but let me say it now. How do you terminate that contract, or how do you notify them that you want to terminate it? Basically just send them a letter saying that you want to terminate the contract. But that letter has to be sent by certified mail. It has to be certified mail. And as long as you do that within the 5 days, 5 days of signing the contract, then you've got no problems. Now, does that letter have to be received by the timeshare company within the 5 days? No. The law just says as long as the letter you're sending is postmarked within 5 days, then you're fine. But again, it has to be by certified mail, and it's got to be postmarked within that 5-day rescission period. And then within 20 days of receiving that letter, they must return the money. 100% of it, all of it. Okay. And then the statutory authority to enforce this act, we kind of touched on it, is the Real Estate Commission. The South Carolina Real Estate Commission enforces the Timeshare Plan Act. They like to ask questions like that too, about any law. Who has statutory authority to enforce the law? In this case, it's the Real Estate Commission. Another law, the South Carolina Smoke Detector Law. Not a whole lot here that for test purposes to worry about, but a couple of things you need to know. First of all, a question they like to ask, how many smoke detectors are required by law to be in a residential property? And the answer is, there has to be at least one operable, operating smoke detector on each level of the property. So if you got just a single story home, then you must have at least one operating smoke detector. 2-story, then you've got to have at least 2, and so forth. So 1 for each level. Now, y'all, obviously, I would hope most people have a lot more than that. I know me, I got 1 for every bedroom. But anyway, so make sure you know at least 1 per level. Y'all, in paragraph B, basically what it's saying here, it says you cannot convey title to real estate unless smoke detector is installed and functional. It's got to be operating. It's got to be working. In fact, if it's ever determined that this property was conveyed to somebody else, and God forbid it burns down, and it was determined either there was no smoke detector or the smoke detector was not operable, was not working, seller, you're going to have some issues here. So it better be working. Just be aware of that. All right. Moving on to the next law is the South Carolina Coastal Zone Management Act. Now, this particular law does not necessarily pertain to every real estate agent in South Carolina. Obviously, this deals with counties that are along the coast of South Carolina. I think there's like 6 or 7 counties. Actually list them there in your book, but you don't need to worry about trying to memorize the counties that are affected by this law. But what you do need to know is this: if you're selling real estate that happens to be along the coast or in any one of these counties, this is when this Coastal Zone Management Act would apply. Now, who enforces the Coastal Zone Management Act? DHEC. Department of Health and Environmental Control. Again, they could ask you stuff like that, so just know who enforces what laws. So DHEC has this one. But what do we need to know about this act? A couple of things. One, part of this act is dealing with what we call the Adopt a Beach program. And basically what this program is all about, they allow or offer to both civic organizations, different companies, to actually adopt approximately a mile of beachfront. A whole mile of beachfront. You get to adopt it. Now, what does that mean? What are you going to do with it? You're going to clean it up. That's what you're going to do. They pick up the trash, keep it free of debris, and just trying to keep our coast, our beaches clean. So a lot of times you'll see where companies and civic organizations, they'll adopt about a mile of beachfront, and they just go out there from time to time picking up trash and so forth. The advantage to that, I'm sure they allow advertising, be a sign somewhere out there where this company is keeping this beach clean or whatever. But that's what the Adopt a Beach program is. But here's the main part of this act, it's called the 40-year retreat policy. And basically what we're dealing with, if you buy a house that's on the beach, beachfront property, erosion could be an issue, right? Especially if the ocean rises, water starts moving in closer onto the land or further into the land, it creates erosion, and at some point it could actually get to your house and actually cause some problems here. So there are some disclosure requirements that are mandated by this law, where it kind of makes sense. If you're buying a house on the beach, wouldn't you like to know how long you could expect to own it before it falls off into the ocean? Right? That's in essence what this 40-year retreat policy requires. We have to establish what we call setback lines. And a setback line is not just for the coast. You see this on almost any property. But a setback line is different than potentially your property line. A lot of times your property line might be way out here, but then you'll notice inside the property line, just inside of it, you got setback lines. And y'all, that means, y'all, if there's a setback line, you cannot build anything or construct anything on that property that would cross over the setback line. So you can't just build something all the way to your property line. You got to make sure you keep any buildings within wherever the setback line is. Y'all, that's just real estate in general. But it's a bigger issue here along the coast, obviously. So where is this setback line? Well, it said it starts with the baseline, which runs across the crest of the primary oceanfront sand dune. So you got to start with the baseline. And it's saying the baseline runs right across the sand dunes. Y'all, that primary oceanfront sand dune, right across the top of it, be the crest. That's considered the baseline. Now, once we know where the baseline is, y'all, the next thing it says, y'all, because now we're trying to figure out again, where's the setback? It says the setback will be a distance of 40 times whatever the average annual erosion rate is for that zone, but not less than 20 feet. So from the baseline, you got a minimum of 20 feet landward of the baseline, or up to 40 times whatever that average annual erosion rate is for that zone. So obviously, if you're working along the coast, you better know what is that average annual erosion rate, because y'all, it will vary from one location to another. So agents that are working or planning to work along the coast, y'all, that is something you're going to be getting very familiar with. So, y'all, just to give you another example, let me see if I can draw something here for you to try to make sure you understand what we're talking about. But y'all, let's say all this is the ocean. And then right up here is the beach, right? Y'all, that's where everybody likes to lay in the dirt and cook for some ridiculous reason. So that's the beach. And then a little bit landward of the beach, y'all, you've got the sand dunes, right? Well, right across the crest, y'all, there, that is the baseline. And then from the baseline, still going landward, y'all, we know the setback line, which would be right here, has to be a minimum of 20 feet, right? Again, that's the setback. Can't write too good. But it's a minimum of 20 feet or 40 times whatever that erosion rate is for that zone. Y'all, that's what you need to remember about this act. Y'all, you got to be familiar with this 40-year retreat policy, which basically establishes where the setback line is. Where the setback line, y'all, for example, y'all, your property line might, y'all, say this is your property. Whoops, y'all can't even write. Y'all, that's your property line. Or your property line. But the setback line is right in here. So even though you own this area here, you can't build anything. Y'all, you got to keep that house on this side of the setback line. Right? Y'all, so that's the purpose of it. But y'all, obviously, as the erosion takes place, both the baseline and obviously if the baseline moves in, the setback line is going to move in. And I will tell you, there are many houses along the coast of South Carolina where the house is now sitting seaward of the setback line. So obviously you buy that house, you better just know, one, you might have a hard time selling that, for one, and two, it might be underwater before you know it. Y'all, you just never know. But y'all, that's what the 40-year retreat policy is all about. Y'all, the next thing they're talking about here are these restrictions. We're still talking about the coastal zone, but y'all, is it possible you could build or construct something that would actually go seaward of the setback line, or maybe even the baseline? Y'all, potentially you could, but obviously that's going to require a permit. You'd have to request a permit from DHEC. and assuming that, and I will assure you, these permits will not be easy to get. But if you get it, then y'all, they list some things here that you could potentially do seaward of the baseline or setback. Wooden walkways, decks, fishing piers. Now you notice it says these fishing piers. If you decide or even get approval to put a fishing pier in the ocean, just know it's going to have to be open to the public. You're not going to have your own private fishing pier off the coast of South Carolina anyway. So they may allow you to put a fishing pier there, but you won't be able to control who goes onto that pier at all. It's open to the public. Golf courses, landscaping, again, you just see some of the examples that could be allowed to be built, but again, you must have a permit. Now there is a disclosure statement that has to be in the contract of sale dealing with this policy. And that is, it says 30 days, and apparently I would remember that 30 days, after adoption of the setback line, disclosure statement must be included in the contract of sale for all properties that may be affected by the setback line. So again, we were just talking about that. Some properties are currently sitting either very close to the setback line or maybe even be over the setback line, again, because of the erosion that has taken place over the years. Within 30 days of that setback line being adopted, because every now and then they'll move, because of erosion, they may have to move the baseline, which in effect, again, moves the setback line. And once they have moved it, within 30 days, you must make sure that's in the contract of sale to make sure buyers are aware of it. Okay. Now let's look at the next law. The South Carolina Vacation Rental Act. These are like short-term vacation rentals. And short-term means fewer than 90 days. Could be a test question there. If it's over 90 days, then that's not a short-term rental and would not apply to the vacation rental. But then they also list some here, some types of properties that do not apply. Okay, not under this Vacation Rental Act. Just because it's a rental property does not necessarily mean it's a vacation rental, right? So hotels, condos with multiple owners, timeshares, residential properties subject to Landlord and Tenant Act. Obviously, if it's subject to the Landlord and Tenant Act, then that's not a vacation rental. That's just a rental property in general. I will tell you here in the Midlands of South Carolina, just to give you an example, these vacation rentals are very common around Lake Murray. Believe it or not, there are a lot of people that own houses around Lake Murray. They don't live in the house. They actually rent them out as vacation rentals. They rent them out for a week at a time or a weekend at the time or something like that. But that's what we're talking about with this law. These vacation rental properties, short-term vacation rentals. But it says, it's saying here, vacation rental agreement is not valid unless, basically what they're saying in common terms, once the tenant has signed a rental agreement or paid money towards the vacation rental, or if they take possession of the rental property, then you now have a valid rental agreement. I think that's kind of common sense right there, and I don't think it's a big deal there. But obviously, any monies the owner would take in advance, because a lot of times these vacation rentals are scheduled weeks or sometimes months in advance, and they will typically have to put up some amount of money to hold the property for whatever date they want it. Well, that money has to be kept in the trust account. In paragraph C, it says the management company that does not comply with this act is subject to disciplinary action by the Real Estate Commission. And then the management company must ensure owners know the requirements of this act. So if you're a property manager and you've been hired to manage a vacation rental property, it is your responsibility to make sure that property owner knows what the laws are concerning vacation rentals. Because most people don't. They just don't. They're buying it as an investment because they think they can make some money renting it out, but they don't know all the laws that go along with it. So that's going to be your job as the property manager to make sure the owner knows the laws concerning this act. Now, in terms of transfer, they're talking about if you decide to sell the property. If you got a vacation rental and you're going to sell it, the buyer needs to understand that any rental agreements that have already been signed, they must be honored if they were signed within 90 days of closing. It says of recording the deed, but basically of closing. So from the time the buyer buys the property, any of these rental agreements that were already in place that are within 90 days of closing, you still have to honor those leases. Now, anybody that signed an agreement that's more than 90 days from closing, those can be terminated or canceled. Again, you got to return their money and whatnot, but you don't have to honor them. But anything within 90 days of closing, you got to honor those leases. Be a good idea to remember that. But it also says the seller must disclose to the buyer prior to ratification of the contract. That's important. You got to make them aware of any future rental agreements. So, the buyer has the right to know if there are any future rental agreements in place. And if there are, how many, and give me the details to it. Now, again, the question they would probably ask you, at what point or when must the seller disclose to the buyer about future rental agreements? Prior to ratification of the contract. I would remember that. Okay. But then it also says, again, seller, if you're selling the property, you must also disclose this sale to the management company. Assuming there is a management company managing the property, you got to let them know within 14 days of entering into the contract of sale. I don't know why you'd wait 2 weeks after it's under contract to notify the management company, but that's what the law says, so that's what we're going to go with. Here it's just saying the tenant must comply with evacuation orders. If a hurricane is coming this way, a lot of times, in fact, almost every time, the governor will issue evacuation orders and you get out of there for safety reasons. But you ever notice that you got a lot of people saying, no, I'm going to stick it out. I think I'll be just fine. Bring on the hurricane. And, and there's really nothing, you can't be forced out of your own property, even though the governor has issued a mandatory evacuation order. But it is enforceable if it's a vacation rental. So if you got a vacation rental property along the coast and a mandatory evacuation order comes out, whoever's currently renting that property, they must leave. That is not an option for them. They cannot stay and sit and try to stick it out. Gotta go. So if you're managing the property, that's something you better make sure people know about. All right. And then lastly about this rental act, I was talking about, if the seller fails to disclose the rental agreements to the purchaser, it's not going to void the sales contract, does not create defect in title, and it does not cause an action against the purchaser or create a cause of action against the purchaser, attorney, lender, and so forth. What they're saying is, the deal's still going forward. We're still going forward. But does that mean the seller will suffer no penalty or suffer no damages because they did not disclose all the rental agreements, which we just talked about, they have to disclose, right, prior to entering into the contract. There still could be, if the buyer suffers damage because they were not made aware of these rental agreements, then obviously there's legal action that could be taken against the seller for that. But the law was just saying, but basically, buyer, you can't use this as an excuse to void the contract. Now you can sue for damages, but you're still buying the property. Basically, is the way I'm reading that. Okay, moving on. And I think the last law we need to talk about here is the South Carolina Residential Property Condition Disclosure Law. And basically, this is a law that's saying if you're selling a residential property, then seller, you must disclose in writing all known problems, defect, issues, material fact, whatever it is concerning that property, you have to disclose it. Now, two potential questions you see right here. What properties are required to have a property disclosure statement? And by the way, you can't just make up your own disclosure statement. This is a state form. The state has already drafted a form. It's like 5 or 6 pages. And there's a lot of questions that you got to answer. So you got to use the state form and you got to answer every question. Okay? But what properties does this law apply to? And is, all residential properties that would be considered single-family homes up to 4 dwelling units. Remember, because we talked about in an earlier chapter, once you get to 5 units or more, that's considered multifamily. And this does not deal with multifamily. It's just single-family homes up to 4 dwelling units. I would remember that. They will probably ask you, when must this disclosure statement be provided to the buyer? And it says it must be completed prior to entering into a contract of sale. Makes sense to me. It says the buyer must sign. The buyer has to sign the property disclosure as well, just indicating that they have in fact seen and acknowledged what the seller has said about the condition of the property. And then a copy of that executed document, property disclosure that the buyer signed, needs to be attached to your offer and sent in together. Okay? And then the third bullet just saying that it is the seller's responsibility to both complete and deliver the statement to the purchaser. And I'll just, so we don't gloss over this, the seller is responsible. One, to fill out the form, and the seller is responsible to getting it into the hands of the buyer. Typically, I think most real estate agents feel like, we all understand the seller has to fill it out, but then it becomes the agent's responsibility to make sure the buyer gets a copy of it. That is not what the law says. The law says the seller is responsible to complete and deliver the statement to the purchaser. Now look, there's nothing wrong with the agent assisting the seller in getting it to the buyer. But if it never gets to the buyer, who's responsible? The seller. That's what the law says. Okay. There's a copy of this disclosure statement in your book, in your material, and you can kind of look at it. We're not going to go through all those questions. You can look at it yourself. But you'll notice out to the right of every question, you have to either check yes, no, or no representation. Well, what does that mean? Well, obviously, if you check yes, and I'm just going to kind of hit on this real quick, but if you check yes, you're saying, yes, I know there are issues concerning whatever the question's asking about. Yes, there's a problem. But if I check no, please understand this. No does not mean there are no problems. No just means I have no knowledge of any problems. Y'all, that's a big difference. Y'all, there could be a lot of problems with a house that the owner actually didn't even know it, had no knowledge of it. So, y'all, I think a lot of times even agents believe that no means there are no problems, and that is not what that means. It just means I have no knowledge of any problems. And then if you check no representation to any question, now, y'all, here you could be getting into some legal stuff, but the law does say if you check no representation to any question, you need to consult with an attorney to determine any potential liability you could have for checking that answer. Y'all, so I don't even like to go there, to be honest with you. But what does that mean? Y'all, I guess y'all, you got to talk to an attorney about that. But in essence, what we're believing it means, because y'all, there's a lot of uncertainty here, to be honest. But basically, you're pleading the fifth. You're saying, yeah, well, maybe there is a problem, but I'm not discussing it with you. Well, y'all, it very clearly states in the law, if the buyer buys this property and then discovers a problem, and we can show that you knew about it, there's no way you didn't know about this and you didn't disclose it, you're still going to be liable for it, regardless of what you checked on here. Y'all got to disclose all defects, and y'all, material defects can never be kept confidential in nature. Cannot be kept confidential. You must disclose all known defects. Y'all, the next thing you see here are 13 exemptions. Y'all, there's a whole page that lists 13 exemptions. Y'all, obviously, anybody that meets any of these 13 exemptions would not have to provide this property disclosure form. And again, I'm not going to go through all 13. You can read them yourself, but there's two of them I do want to touch on. Because I know one question, I know they like to ask about the exemptions. They'll ask you, which of the following exemptions do you think would be the most common exemption? And I think it's number 10 in your book. I may be off on the numbering. I think it's number 10, but at any rate, the first sale of a dwelling that's never been inhabited. Brand new homes. So builders are exempt. If it's a new home, property disclosure is exempt and does not have to be provided. That's the most common exemption. I would remember that. The other one that they like to ask about, that I would suggest you also understand or know, is number 13, the last one. And it says that when the disclosure statement exempt if both parties agree in writing not to complete the statement. So in effect, can the buyer exempt the seller? Yes. Could the buyer say, you know what, I don't need it, I don't care, I want the house? As long as the buyer puts it in writing that the seller does not have to provide this document, then seller, you're exempt and you don't have to provide it. But if that buyer does not sign something in writing saying that, I'm telling you, verbal's not going to cut it, seller. You better have something in writing or you're going to have issues. So what are material defects? You're going to get this from sellers also. Well, what is material? What are you talking about? What do I have to disclose? Well, you see right here in the law, I think it lists like 7 different items there. Some examples of what a material defect would be. Again, I'm not going to sit here and read this to you because I know y'all can't wait to read it yourself after this video's over, but it's common sense stuff. If anything wrong with the house, disclose it. I don't know why it's such a big issue. Do you have any knowledge of anything that doesn't work or anything that needs repair or any kind of damage? Anything that's not right, then you have to disclose that. This is not, sometimes we try to make things difficult when in fact it shouldn't be. But here's a provision in this law very similar to that Vacation Rental Act, if you recall. Failure to provide the disclosure statement. If the seller does not provide it, even though it's required by law, buyer, that is not a reason to void the contract of sale. It does not create defect in title and is not a reason to delay or put off the closing. So what they're saying here, first of all, buyer, when were you supposed to acknowledge or get a copy of the property disclosure? Before you signed the contract of sale. So if you signed the contract of sale before you ever got a copy of this disclosure, then buyer, you're kind of complicit here, right? So you can't use this as an excuse to get out of the contract. Now again, none of this diminishes or takes away potential liability against the seller for damages because they did not disclose. There's still liability here for the seller. We're not trying to say there's no liability, because there is. And here they're talking about making changes to the disclosure statement. Is it possible at the time the seller filled out the property disclosure that they had no knowledge of a potential problem, but at some point later it is brought to their attention that there are problems? Now you got to go back and fix or correct the statement. You can't just leave it the way it was and say, well, at the time I filled it out, I didn't know it. Okay, but now you do know it, and you have to go back and correct it. So you do have to do that as well. And it also saying here about the buyer's obligation to inspect the property. Buyer, you have a due diligence period, or you're entitled to a due diligence period, which means you should get a home inspector to go out and inspect the property. Now, do you have to do that? No, you don't have to. But I'm telling you, and according to the law, buyer, if you choose not to have the home inspected, then you basically waived any rights you may have had against the seller for not disclosing an issue. So buyer, you still have an obligation to get it inspected. Again, because it kind of goes back to the question, if they check no, again, they're not saying there are no problems. They're saying I have no knowledge of any problems. So you better get it inspected to make sure we have knowledge of what potential problems actually may be, right?